Ladies and gentlemen, please welcome the Dean of the USC Marshall School of Business, James G. Ellis.
Good evening. I don't know that I've seen this many billable hours in one room in my life. It's nice to have you all here, even though there's some opportunity costs that are being missed, but great to have you. On behalf of University of Southern California and Marshall School of Business, it's really our pleasure to welcome you to our forum on leveraging IP in today's knowledge economy. You know, it really makes up a large portion of the value of so many companies, and it's so critical, and I think that you all are wise to be here to learn about how to utilize and unlock the value of IP in the various ventures. This came to us as a thought, and one of the things that we at the Marshall School love to do is to be entrepreneurial in our practice. How can we teach entrepreneurs if we aren't entrepreneurs? And we need to do that. We need to do new things. We need to say yes. I give great kudos on that to our namesake, Lloyd Greif of the Greif Center of Entrepreneurial Studies, who's with us. Lloyd, thanks for being here. Lloyd has really helped in so many ways to build the Greif Center to what it is. We started in 1971 as the first entrepreneurship center in the country. And during this period of time, we've educated tens of thousands of undergrads and had a lot of startup businesses that have been highly successful. But when you do that, there are so many other things that you want to take advantage of and helping students with it. And that's why it's great that our students, some students from Santa Monica City College are here. Great to have you all. Welcome to the USC campus. But it's really wonderful to have you all to think about being entrepreneurial, but to think about how IP really plays into what you do in your businesses and in your environments. A matter of months after the idea came to us from Dr. Gary Michelson about having intellectual property taught at colleges and universities, not just law schools, it's no surprise that one of our guys said, we want to be the first ones to do this. And very quickly, the Entrepreneur's Guide to IP was started as an undergraduate course with Professor Luke Dauchot teaching it. Luke, thank you for what you've done. We really appreciate it. Thank you very much. We have a number of guests with us that I just want to mention and call out their names. The Honorable Paul Michel, who's the retired Chief Judge of the United States Court of Appeals for the Federal Circuit, is here. Judge, I know you are because you and I just said hello. Where are you? There you are, right there. I can't see you, but I know you're here. Thank you. I think the Honorable James Otero, Judge of the United States District Court, the Central District, is here. Judge Otero, are you here? Did I see you? There you are back there. Thank you. And we also are expecting the Honorable Andre Baratz, who's the Judge of the United States District Court for the Central District of California. Is he here? We haven't seen him yet. I didn't know if he was or not. And the Honorable Ronald Liu, Judge of the United States District Court, Central District. I don't think Ron is here yet either. Is he here? You are there. Welcome. Great to have you. Thank you for being here. And the Honorable Michael Wilner, U.S. Magistrate Judge. Michael is here, and he and I said hello together as well. And where are you? Way back there. Thank you for being here. And finally, another U.S. Magistrate Judge from Los Angeles, the Honorable Suzanne Siegel. Is she here? Anyway, it's nice to have you all here. Thank you very much for coming. We truly appreciate it. It's an honor that you've taken the time to join us here on campus, and we welcome you. You know, it's an interesting thing when you do something like this, that so much of what happens in any organization really is a function of the leadership of the organization. And the leadership of USC is in wonderful hands with our 11th president, C.L. Max Nikias. So I'd like to invite President Nikias to the podium, please, sir. Thank you.
Thank you, Jim. Good evening, everyone. Good evening. Great inventors share two qualities: the passion for discovery and the freedom of imagination. Thomas Edison's light bulb came from combining known elements in a new way. But William Shockley's transistor, invented many decades later, involved completely new physics. Both inventions were patented, and both inventors changed the world. Dr. Gary Michelson is in their company. A retired orthopedic surgeon, he's one of America's great inventors with well over 950 patents worldwide. That outpaces Thomas Edison. But this kind of innovation can lose traction unless the intellectual property rights behind it are safeguarded. With today's global markets, protecting intellectual property is critical to economic growth. This is why Dr. Michelson is working hard to elevate the discussion. And tonight, USC partners with him. The more we talk about intellectual property, the more we can affect change. For more than 2 centuries, the US Patent Office has promoted and protected intellectual property rights, but the world is so much more complex. In its first 50 years of numbering patents, the United States issued 300,000. Today, it issues far more than that in a single year and will soon hit a total of 10 million. This acceleration in innovation isn't just about patents, though. It's also about the science and the technology that drives them. That's especially pronounced in biomedicine. On Wednesday, our university opens the much-anticipated new state-of-the-art building for its Michelson Center for Convergent Bioscience. It will bring people from across the university, a place where our best minds will tackle our most daunting health problems. The center's interdisciplinary approach in a building without borders will make USC one of the leaders in achieving groundbreaking research through convergence. And inside, our scientists, doctors, engineers, mathematicians, and their research teams will be creating the future, one in which intellectual property rights is a driving force. The economic importance is undisputed. Intellectual property today represents 38% of America's total GDP and 80% of the market value of all publicly traded companies in the United States. Yet, no top-tier American college or university offers any undergraduate course on how patents, trademarks, and copyrights work here in the United States. Dr. Michelson and USC changed that. Our Marshall School of Business this fall introduced a new undergraduate course through the Lloyd Greif Center for Entrepreneurial Studies called the Entrepreneur's Guide to Intellectual Property. The class is taught by Luc Dauchot, a nationally known litigator who will join the stage this evening for a lovely conversation. Mr. Dauchot served as a counsel to Dr. Michelson, who had challenged a medical device maker over its use of his patent-protected surgical inventions. And jury ruled that in Dr. Michelson's favor, leading to a record of $1.35 billion settlement, which included $800 million to acquire the patent rights. As Dr. Michelson likes to say, if you cannot protect what finally makes it to the pipeline, there is no pipeline. A man of great commitment and generosity, Dr. Michelson isn't afraid to disrupt the status quo, to think differently, to see new possibilities. One example is his 20 Million Minds Foundation, which was created to provide low-cost or free textbooks and became centered on improving access to higher education. And now, for tonight's discussion, I would like to invite to the stage Mr. Luc Dauchot, and a man who will never stop trying to improve the lives of others, a man I'm proud to call a friend, Dr. Gary Michelson. Can you please join me up here?
Dr. Michelson, I wanted to introduce you to the group by asking you just a few questions. President Nikias did a terrific job introducing you, so I wanted to get beyond some of that. What led you to innovation?
I don't know how close this needs to be. Is this good? Great. That's the same size hand that Wilt Chamberlain had. We stuck them up there together because he said he could palm a 16-pound bowling ball. And if you're the patient, would you want that inside of you? No. So it is true that necessity is a mother. I mean, it's the mother of invention. So the reality of it was, when I was in medical school, I watched surgeons working, and everything was for their convenience. The incision was just as big and long as it took to get their hands in, to stick their head in without their ears touching so they could look around. And that just struck me as wrong, even back in medical school. And it is possible to visualize the inside of a body without doing that. We all know that now. We have arthroscopy, we have image intensifiers. And the other thing is, if you can satisfy yourself to not stick your hands in, the incisions can be 1/4 of an inch long, 1/2 an inch long, and you can stick a long, skinny instrument in. So that was the beginning of it.
And then you progressed onto other innovation, and I want to focus on the spinal, the instruments and the methods that you invented to access the spine in order to deal with compromised vertebra and compromised discs. Can you explain a little bit how you got there, and how you approach the problem in terms of leveraging your innovation?
So doctors are supposed to be smart. They can't all be equally smart. And just because you're smart doesn't mean that you have coordination or hand skills or whatever that is, or artistry. And one of the challenges has been the reproducibility of results, particularly when you're working in the spine. So one of the goals was, I think that the Prince tennis racket really revolutionized tennis for the weekend tennis player. It didn't make any difference to a pro. But the same was true of the Big Bertha Golf Club. And so one of the things that I was trying to do was devise new procedures that had their own implants, but always with the idea that the instrument set wouldn't really let you deviate. It wouldn't let you get out of what was a high-quality result. It had all kinds of safeguards built into it, and it took away a lot of the things that happened inadvertently that were undesirable.
One of the things you told me, Gary, that stuck was, I mean, you're a physician, you're a surgeon, and much of your days were occupied in the OR. And we were talking about the contributions of your inventions and how more of your time was now getting spent on the inventions as opposed to actually dealing with patients in the OR. And this is starfish. You mentioned something about starfish and that story. Can you share that with the group? It impacted me.
Yeah, so I don't know how to say this any better than this, other than to say that invention is the great magnifier. It allows you to do things on the grandest of scales. So yes, I can go to the operating room and do something for one patient, but if you invent something that 30,000 spine surgeons can use to help 1,000 patients a year, that's unbelievable.
Right. I want to shift gears, Dr. Michelson, and focus a bit on the 20 Million Minds Foundation, which President Nikias mentioned in his introductory remarks. What was the impetus? What led you in that direction?
I think it was 2008. I was having coffee. I read the paper, and it said that at one of the 112 community colleges that happened to be in a very poor Hispanic neighborhood, that there were X number of 100 kids who had B or better averages in the first year who were not returning to school, and that 80% of them stated the reason was they could not afford the textbooks. And when you look at the cost of textbooks, it's outrageous. Most of the courses that you need to get through 2 years of community college or the first 2 years of four-year college are generic material. They haven't changed trigonometry, they haven't changed any of the foreign languages, on and on. So why are these books $185 each? And it turns out there's a cartel, there's 5 publishers, and goes on and on. But so I called up this school because here's what got to me. It said that the teachers there, a big group of them got together and were willing to take $500 out of their pockets to help buy the books for these kids. And that wasn't going through some foundation. That's a lot of money to a teacher. So I called them up and I said, how much are you short? Rounding it off was $50,000. So I gave them the $50,000. Now, you're supposed to feel good when you do that. I did not feel good. I was trying to go to sleep that night, and I was sitting there thinking, wow, that really isn't good. There's another 111 community colleges, and there wasn't anybody giving them the money, so that wasn't the answer. The answer was to produce super high-quality textbooks and give them away for free. Put them online, make them digitally downloadable, and if you're doing that, as Phil Kim, who's here tonight, could tell us all, you might as well make them interactive. The problem with that is you don't need the universities anymore. So we got a lot of pushback on that. Universities do a lot of things, but you don't need a university to read a book. So that goes on from there, but that's how that all got started.
And why was IP, intellectual property, part of that program among those textbooks?
So Judge Michel, myself, the gentleman who is the chief patent counsel for IBM, and a bunch of people sit on a board, which is the Intellectual Property Owners Education Foundation. And we used to sit there and preach to each other, but we weren't preaching to anybody else. We weren't getting the message out. And, you know, there's this idea that information is straining to be free. Well, only up to a point, because then everybody goes out of business. So who better to create another textbook, because we had already done a bunch of them. This one would be on intellectual property and geared to the college space, but also allowing it to be walked down so we could teach it in high school, junior high school. And since then, we made a series of videos. They're only a couple minutes long. They're very easy to watch.
Okay. And one last question, Gary. Why the undergraduates? Why did you approach USC about having the school teach a course specifically to undergraduates, as opposed to law school or other postgraduate programs?
Just look around, whether it's Facebook or it's Twitter or it's Google or it was Microsoft before. All of these companies were started by people who are in this college demographic. Whether they dropped out of college or not, this is the right time for them to understand the importance of intellectual property.
All right. Thank you, Dr. Michelson.
Thank you.
I think we're done. You're out of here. Hey, thanks. With that, I am going to invite our panel up to the stage to start our discussion. No signal. All right. While our AV people, are you seeing a screen? No. All right, the best laid plans. Okay, well, while we're doing that, I am going to introduce our panel members, beginning with Judge Michel, who, as President Nikias mentioned, is and actually, I came ready with paper copies of the presentation, just in case something like that would happen.
Too.
There we go. I owe that to a friend and a colleague, Bob Krupka, who's among us. He's the one who was responsible for me coming to Kirkland. And by the way, President Nikias, when you mentioned the success that Dr. Michelson enjoyed in that lawsuit, Bob Krupka deserves more credit than I do. But that's neither here nor there. Okay, we have it up and running. Let me get my my clicker here. Where's my clicker? Oh, for Pete's sake.
It's right there.
Where did I put it? On the table. Okay. I know. Where would I be without you? Okay, here we go. Let's see. There we go. All right. Well, I'm going to begin by introducing Linda Lloyd de Silva, who's Director of Communications of the World Intellectual Property Organization. Linda, welcome. And I am not going to spend a whole lot of time introducing our panelists because I think we want to hear from our panelists. This brings to mind something that somebody from our class once told me. He says, hey, Professor Dauchot, are we going to hear from a big shot tonight? And I'll just cut through it all. And for my students and others here, these are all big shots. Next, we have Alan Lowe. Alan, thanks for joining us this evening. He's Vice President, Deputy General Counsel, Head of Intellectual Property for Facebook, and a graduate from the Ohio State University. I took a look. I think USC historically has your football team bested, although
I'm not going to talk about that.
Although I think this year you're just fine in the rankings. So I'll shift gears. Judge Michel, who is a former chief judge of the United States Court of Appeals for the Federal Circuit. Judge Michel, what an honor to have you among us. Thanks so much for joining us.
My honor to be here.
If you watch the news and you hear some of the stuff going on in Washington, D.C., and you know you hear about Watergate, I mean, most of you are too young to remember Watergate. I'm sure most of you weren't born when Watergate took place. But in any event, if you hear about it, Judge Michel was part of the prosecution team. Just a little bit to the bit. And afterwards, if you want to talk with Judge Michel about it, please do so. I'm sure he'll be glad to share. Mark Ringus from IBM. Mark, thanks so much for being here.
Happy to be here.
You joined IBM in 1992?
That's correct, yes.
That's unusual. That amount of longevity, and it's a credit to you. We really look forward to hearing from you.
It's a great company. I'm happy to be.
Last, certainly not least, Suzanne Wilson. And Mark, by the way, University of Michigan.
That's correct.
And I hate to tell you, I took a look. Historically speaking, SC has the University of Michigan bested as well. Sorry about that.
That's all right. Our time will come.
And this, well, it's certainly not this year. Last but not least, Suzanne Wilson. Suzie. I've got it. Suzie Wilson, who joins us from Disney, and you're a Golden Bear.
Yes.
And yes, we
do not talk football.
We're not going to talk about. We're not going to talk about football. You joined the company in 2012.
2011.
2011. Okay, and Suzie runs all of IP. For the Walt Disney Company, and we look forward to hearing from you as well, Suzie. Okay, with that, quickly go through what we're going to touch on this evening. We're going to touch on the U.S. patent system and how it's doing. Specifically, is it really promoting innovation today? The second topic's going to be digital copyright protection. And the question is, are we doing enough, in particular when it comes to piracy? And you just heard part of the value of digital information. Dr. Michelson shared it with us in terms of what he's doing with the textbooks for the 20 Million Minds Foundation. And it's a broader issue than that. But I look forward to getting into that. And then we're going to touch on just the world stage. How does our IP system stack up? We may not hit all of these issues independently, but that's going to be in the mix. All right, with that, a number of years back, and I want to go back, reach back 10 or so years, there was an increasing clamor, if you will, on Capitol Hill about the need for patent reform. Alan, Google was a part of that well before you joined the company, I appreciate. But could you give us some perspective on what the issues were back then? And since then, we've had attempts at reform. And from your perspective, how well that reform has served us?
So I'll try to do this in a nutshell. If you go back, and even before this quote that you have here, in the 90s, mid to late 90s, one of the things that we saw emerging in the patent system were entities whose sole business were monetizing patents. So they weren't making products, but they were getting patents and then making money by either threatening to sue or license, and then eventually licensing their patents.
The patent was the business.
The patent was the business, and they're affectionately called non-practicing entities today, NPEs for short. Some people use other words to describe them.
Well, we've heard trolls. I'll use the word.
Okay, so you've used the word troll. And that's, I think people view that as the pejorative term. But I think by the early 2000s, we were seeing more and more of this. And then we had the dot-com bubble burst. And all of a sudden, we found there were a lot of companies that were no longer in existence, and their patents were being sold off to these NPEs. And so what we saw was that this was a phenomenon, particularly in the high-tech space. And so it wasn't emerging so much in the other industries, but in high-tech. And while the number of litigations were somewhat limited at that point, and they were rising, a lot of what we saw were the threats and the letters and the negotiations and the way these entities were handling themselves. And one of the things that they were taking advantage of were inefficiencies in the system itself. And so the litigation system has certain behaviors. To defend a patent litigation may cost you, I think some people cite $5 million. That's to defend through trial, and that assumes you win. If you lose, it'll cost you even more.
And that may even be on the conservative side.
That could be on the conservative, it could be more. It depends on the complexity of the case. And so what we were seeing were entities who would get patents, would make allegations of infringement. They knew that companies would have to spend millions just to defend, and they would make offers to settle for a fraction of that cost. And we knew that these were cases that had no merit, but our choice was to spend a lot of money fighting or rolling over and just paying the money. And one of the things that also was happening at that time was the patent office was issuing more and more patents. And so we were seeing the numbers, the filings and the issuances increasing. And so we see today that any given product will have thousands, if not 10,000s of patents that cover that product. And so one of the statistics that's cited is that a smartphone has as many as 250,000 patents that you might be infringing if you were to release a smartphone. And so how do you deal with these assertions that are being made where you've got entities taking advantage of inefficiencies in the system? You have numerous patents being issued on a weekly basis, and how are companies then supposed to be successful, make products? And so what you see here, and really what was happening, I think, in the early 2000s was certain companies were seeing this phenomenon and trying to speak out and say, hey, we've got a problem. And one of the challenges, and I think for me, what's significant about what you've cited here are two things. One is perspective. Smaller high-tech companies were seeing this problem. And the challenge that small companies had was they couldn't afford to defend. And so they really had a gun to their head, and they had to just pay to make these entities go away if they were going to try to build a company. And so you have this different perspectives, but the other companies in other industries weren't seeing this. And so in the pharmaceutical industry, in biotech, in other industries. And so some of the clash that was happening were just companies acting very reasonably, but having very different perspectives, very different experiences in terms of what they were seeing in the patent system. And the patent system was working really well for certain industries, just not so well in other industries. The other thing that I think you see here is a reminder that I think at that time was not, we didn't really talk about it a lot, but it was really about what was the purpose of the patent system? Why did we have it? And were these problems we're seeing, were they taking us away from achieving the goals of the patent system? And I think back then a lot of the conversation was the system is the system. Just as long as you operate within these rules, it's fine, it's legitimate, it's okay. And I think the call for reform was, well, what if the rules are bad? What if the rules are wrong? What if they're promoting the wrong kind of behavior that actually is bad for startups, and we need to change the rules? And so I think that's what we saw. And for many years, legislative reform didn't happen because we didn't really have a lot of agreement. I think if you fast forward to where we are today, some legislation was passed in around the 2011 time period. And then what we saw was a series of cases that came out from the Supreme Court. So a lot of the legislative reform that I think companies were trying to pass never happened. And instead, what we saw was some piecemeal adjudication and changes of the law over time to kind of get us to where we are. If I were to summarize where we are today in terms of from a high-tech standpoint, I think we're in a better place than where we were. I think early days we were trying to eradicate trolls, which I think was not the right approach. I think trying to close the loopholes and trying to close up the inefficiencies in the system and make the system better was the right way. And it was really about how do we balance the system so that it continues to work in the places where it's working, but we fix it in the places where it's not.
Mark, from your perspective, has reform been effective?
Well, I think reform has been effective in a number of ways, and I think it has done a lot to alleviate some of the challenges of the non-practicing entities and the inappropriate litigation behavior that we often see. I think the question we need to ask ourselves today is whether reform has gone too far. And we've made it too difficult for operating entities to actually enforce their patents and to earn the value from their innovation. And I think that's a really good question that we need to ask ourselves. With some of the challenges from the Supreme Court cases that make it very difficult to enforce software patents and patents in the life science area, and some of the challenges with the post-grant procedures now that are available through the Patent Office and the delays that cause in litigation, and frankly, a system that was designed to try to reduce expenses in litigation is in fact increased the cost and elongated the time frame for an inventive company to actually earn value from their portfolio.
Okay, Paul, Judge Michel, you have some opinions about whether or not we've gone too far.
Well, I think Luke, that the primary goal of the patent system is not so much to incentivize inventors to be creative. As long as they have a job and a paycheck, they'll be plenty creative. That's their very nature. The real target of the patent system is money managers, because it's all about investment. Most useful invention is quite expensive and quite risky. And so it takes money. That's the fuel that drives invention in all settings, small companies, big companies, this technology, that technology. So if we look at where we are today, some of the reforms have had good effects, but the overall macro effects look to me like they've been very bad. So if you look at it from the standpoint of investment incentives, investment in R&D is falling. Patent values are falling. The strength of the American patent system that was always rated #1, this year we fell to #10, tied with Hungary. Hungary is not known for a good patent system. So a lot has changed in just the last few years as the Supreme Court and legislative reforms have reached their full effect. And it looks to me like in an effort to address a real problem, particularly felt in certain industries, we've weakened the whole system from stem to stern in a way that's very counterproductive for the needs of the country, for job creation, for family incomes, for tax incomes, for GDP growth, for productivity growth, for global competitiveness. All of these important features have been weakened by the weakening of the overall patent system in an attempt to deal with the trolls. So it looks to me like we need to readjust and keep the parts of the reforms that are working well and make some retailoring so that the parts that aren't working so well get fixed. It looks to me rather clear that the Supreme Court is not the right place for national innovation policy to be shaped. They're not elected. They don't have the means to do it right. So when they make macroeconomic policy, they often make big mistakes. In the legislation, nobody knew exactly how it was going to play out, how it would be implemented by the Patent Office. We now know the results, and it looks to me like a large number of very bad patents are being effectively killed in the new reviews, but some patents that look to me to be very good are also being killed in the new reviews. So the new reviews are slanted and need to be readjusted, and the Supreme Court really needs to be legislatively corrected. The patent law is statutory law. The eligibility is a short section, Section 101 of the Patent Act, but the Supreme Court basically nullified it and said we're going to do it their way. Well, the Congress ought to come forward and say, no, we're not. We're going to do it our way. We represent the people.
One of the statistics, and this is clear. I mean, Congress has tried to deal with the reform question at the back end, and by that I mean dealing with patents after they've issued. And Suzie, I'd be interested in your perspective. I mean, the statistics coming out of, and for those of you in the audience, I know my class knows about it, but part of the reform was a new administrative process designed to more efficiently and more expeditiously allow parties to challenge patents after they have been issued by the Patent Office. That process has been actually called by some, I think one of your former colleagues on the bench, a patent death squad. But the percentages are sobering. I think easily historically, since this process has been in play over the last few years, well over 70% of the patents that are taken on in that venue are ultimately deemed unpatentable. Suzie, is that a problem?
Actually, I wanted to touch on something that Judge Michael said.
Sure.
The one thing, and I think was mentioned by a couple of the speakers, that currently there's a lot of uncertainty in the system. And I think that goes to the point of, again, having it be judge-made instead of in the actual statutory text. And what that means for us as a practical matter is even if you've done all your assessments up front when a claim comes in and you decide this is something, to Alan's point, that we should fight this, but kind of the shifting sands that have been happening in the patent law area means even though we'll obtain summary judgment in our favor, 2 years later perhaps it comes back down to us. And because the Federal Circuit has decided that the district court judge made a mistake, and then we're dealing with a different fight. And in terms of, I don't think we have been too impacted by the post-issuance review process, but I do think there is an ongoing issue in terms of the non-practicing entities and just the lack of predictability, which I think, despite the reforms, means that litigants will at times, take the bargain that you spoke about, Alan, of even if you think you are right, if you don't know for sure that the laws can actually stay the same all the way through your litigation, are you going to spend $5 million plus on that litigation? Or if they are offering a fraction of that as a settlement, is that the smarter business decision?
Well, I think the problem with that is that there isn't just one troll you have to deal with.
Right.
It's the second and the 10th and the 100th and the 1,000th one who's waiting in line. And what we know from their behavior is that they will identify very quickly which companies roll over and which ones fight. And the ones who fight are not the ones they're going to go after because it's the hard money. They're going to go after the ones with the easy money.
I would actually dispute that a little bit, because I think that, and maybe you have a different point of view on this, I have the sense that some of the large technology companies fight a lot of these cases, and yet I still think most of the cases are probably being filed against them.
Because they have the deep pocket,
Yeah.
for sure. But I can tell you that I know which companies are the ones that roll over, and so do the trolls, and they get sued first. But I mean, coming back to something that Judge Michel said, talked about the Supreme Court as sort of being, are they the right place to fix the system? I think what we have to always remember is the balance that the system has of protecting and encouraging the investment that you talked about, but it's also about making sure on the other side that companies are able to sell products. And when we talk about innovation, we talk about the patent system here is about promoting innovation. It's not just about the creative process of coming up with invention. In particular, in some technology areas, that's the easy part. The hard part is making the product and actually selling it and doing it at scale and being able to do it and supporting 1 billion or 2 billion or 5 billion users. That's really hard. And when you have to deal with a system that basically taxes you so that the stuff that you're doing, the investment you're making is now you have to pay out to someone else. And you have to pay out to thousands of companies. And they're all asking for 1%. That's 1,000%. It doesn't make any sense. And so that's part of the problem that the system has. Now, I think when the Supreme Court tries to deal with this on a piecemeal basis, I agree with Judge Michel 100%. I think what they're dealing with are trying to treat the symptoms and not necessarily trying to fix the system holistically. And that's why things get out of balance. And the Supreme Court and the courts, unfortunately, don't have the ability to do that at a holistic. They deal with cases.
It's interesting from I'm a trial lawyer, but when I try to talk clients into filing a lawsuit here in the United States, it's actually an interesting proposition, right? I tell them, look, if you're going to assert your patent, and presumably if they're thinking about investing $5, $7, $8, $10 million in patent litigation, it's an important, it's an important property right that they're aiming to protect. Well, you file your lawsuit, the odds are that your patent stands a better than 60% chance of getting defeated through this post-issuance review process. And by the way, once you get through it, the odds of you getting an injunction, and for those of you who don't know what an injunction is, it's basically a court order prohibiting another party from doing something, and in patent cases, it's really stopping the infringement. The odds of you getting an injunction are virtually nil. And that's because of the Supreme Court case, the Supreme Court basically dealing with injunctions in patent cases as a way to deal, most viewed, with trolls, and that is make it tougher to get injunctions. A client goes through all that, and they go, well, why should I litigate? I'm going to spend that much money to and have my patent stand over a 50% chance, well over a 50% chance of getting invalidated. And at the end of the day, I'm probably not even going to be able to get a court order to enjoin the other party from infringing. I mean, Mark, is that a problem?
Well, I think it's a huge problem. It seems that we've moved to a system where the patent examiners on first examination are responsible for issuing quality patents, to a system where it really doesn't matter what happens in the first instance with patent examiners, that the actual decision as to whether something is patentable or not, or valid or not, is made in a post-grant proceeding, several years after the initial examination. I don't know why we've moved to a system that allows that detailed second level of review in such a way that really devalues all the work that's done up front.
And what you're saying that, Mark, we have some statistics up here which are interesting. So utility applications, and my class knows this, over the last few years have just skyrocketed. They've grown close to fourfold. And these are, call them patent applications, if you will. But yet, and this surprised me, when we looked at the numbers, I was expecting to see a trend where the PTO, the Patent and Trademark Office budget, would have been steady. as the number of examiners has been steady. And if you look at the stats, and some of my colleagues pulled them up, the budget per utility application filed has grown somewhat, albeit not as much as, and the slide's a little off here, but not as much as the rate of filing. But it's gone up. The number of patent examiners has gone up. Average total pendency, fluctuated somewhat, but basically the same. So what's going on? It seems that the PTO's infrastructure, at least from the perspective of dollars, number of examiners, has kept up. What's going on?
Well, Luke, one thing that's going on is hidden, and that is the IT systems in the patent office are abysmally out of date and totally insufficient to the needs of current searching for prior art and examination in a quality way of patents. And that's partly because the Congress has diverted about $1.5 billion of fees paid by users of the system to other government programs. That money was supposed to go to the patent office, and one of the main uses was to upgrade the IT systems so the examiners would have the access that they need to all the prior art in the world. So Congress has strangled the process. Yes, they have more examiners, but they still don't have adequate IT systems because of this diversion of the fee money. So that's one of the very big problems, and it doesn't show up on the chart of how many examiners there are. If you had a chart of what the IT system performance level was versus what's needed, there's a huge disparity. So that's a big part of the problem. The other irony is in these post-grant reviews, you have 3 people on the board that does the reviews who have less technical expertise than the original examiner had. And yet they are overruling the original examiner in 60-some% of the cases. That seems backwards to me. If you had somebody with more technical experience, it would make sense. But the board members have considerably less technical expertise and specialization than the examiner had. So the whole system is really out of whack. There's a teacher at the law school here and a graduate of this great university who very likely will become the director of the patent office before the end of this calendar year. He's going to have a huge challenge to deal with the procedures on these post-grant reviews and to deal with the problems in the examination process, including the IT systems. And I hope that he will take these problems by the shoulder and wrestle them to the ground, because they certainly need it.
Alan, just one thought here, and part of the idea behind Dr. Michelson's Center of Convergence, what spawned at was this notion that there's almost too much information out there, available out there. And so this mass of information creates a natural tendency to start siloing, right? You can just become an expert in just about anything because there is just so much information out there available. And so part of the idea behind a center is just to get folks working together again and move away from the siloing. And where I'm going with this is, if you think about the patent office, the stat here says an examiner spends an average of 19 hours on an application. And Judge Michel just pointed out that the IT systems are, and I'm probably overstating it, but antiquated over there. Which means that in trying to assess whether or not a patent should issue, and particularly with respect to prior art, you have just an ocean of information out there that's accessible to any well-heeled company set on defeating the patent. But that same information is not accessible to the patent office, to the examiner, particularly in an ex parte context. Ex parte meaning it's just a process that's close to the public and it's between the examiner and the applicant. I mean, what's your take on that?
Yeah, no, I think that's point number one. I think that's exactly right. I think when you look at these numbers, 19 hours is not a lot of time. You're talking about, less than 3 days that you have as an examiner to read the application, to go do research on what has been done before this application was filed, to apply some judgment as to whether or not this should be granted as a patent or rejected, to write it up, and then to submit it. 19 hours is nothing. I mean, and in contrast, when you talk about these post-grant processes, you're talking about dozen, different people involved in doing the analysis and the research and the argument to invalidate a patent, and numerous people searching for prior art. So, is it fair?
It's not even a fair fight.
It's not a fair fight to say one person for 19 hours by him or herself in a room to make this decision versus an army of people who are spending, I don't know what the latest numbers are in terms of what it costs to bring in IPR to challenge a patent, but you're talking hundreds of thousands of dollars of attorney fees. So it's not a fair fight. It's not a fair comparison. And it shouldn't be surprising that the results are what they are, in part because you're going to have a lot of people trying to invalidate a patent versus one person doing the best that he or she can. The other thing you have as well is when we talk about the statistics, it tends to be the worst patents that are going to be the ones challenged. So it, again, should not be a surprise that when we look at the statistics, that the rates of invalidation through IPR are going to be on the high side, particularly in the earlier years. And I think that what we've seen is the numbers actually have come down a bit in terms of the percentages. So
let me push back on that a little bit,
Sure.
Alan. I mean, when you say the worst patent, I mean, it seems it's almost an IPR filing is de rigueur in any litigation. I mean, you do it. It's knee-jerk.
It didn't used to be.
It
didn't used to be, but it is now.
And so pretty much everything is getting attacked, although the stats do show that the rate of cancellation is decreasing, to your point.
We're also seeing more petitions not being accepted. So
right,
that's also another piece of it too. Once they're accepted, there's already a substantial likelihood of it being found invalid. So having the patent office now say we're going to find it invalid should not be a surprise.
I'm not sure these are the weakest patents, because 80% of these reviews involve pending lawsuits. So somebody has already vetted the patent and calculated the chances of proving infringement and spending the $5 or $10 million in 5 or 10 years to try to get a final result, to get a check written.
Or an injunction granted.
Yeah, if they're really lucky. So I don't think it's fair to say these are the so-called low-hanging fruit. These are the really lousy patents, the worst that are out there. I think they're probably some of the strongest that are out there because somebody's already made a judgment that it's worth filing a lawsuit and incurring a lot of expense and a lot of risk. So when the invalidation rate is 60 or 70% of the stronger patents, that it raises a huge question about, well, what about all the rest, and how will anybody ever know? Suzie makes a point about uncertainty. In my new life, I spend a lot of time talking to business people, investment people, economists, think tank people, all sorts of people other than patent lawyers. They all tell me we can live with almost any set of rules if they're predictable and reliable. And if they're uncertain, we can't live with it. It causes huge problems for us. And what we have now is massive unpredictability, massive costs, massive delays. I mean, in Germany, you can get an injunction in less than a year. The case is over. It gets settled as soon as the injunction is issued. In the United States, in year 8, we finally have the last Federal Circuit appeal and a final result. Year 8? $8 million? That's intolerable in the pace of commerce today, to take almost a decade to get a final result and have to spend millions and millions and millions. And these post-grant reviews were sold to Congress as an alternative to expensive district court litigation with discovery and motions and all the rest. Well, they're turning out not to be an alternative. They're turning out to just be the prelude. First, you fight for 3 years in the patent office, and then if you survive that, you fight for another 5 years or 6 years or 7 years in the court system. We've made the system sclerotic. It's just not able to support our invention, our investment, our economy the way it needs to, and we need to make big changes in it really fast.
Mark, on the
I'd just like
yes.
to jump in here for just a minute.
Sure,
representing the international perspective, I couldn't agree more with Judge Michael.
Judge Michel.
Judge Michel, excuse me, pardon me.
All right.
the World Intellectual Property Organization has anticipated the cost to businesses of delays in protecting their intellectual property rights. And one of the things that was set up several years ago was a arbitration and mediation center, which has since been processing more than 3,000 disputes per year and resolving them. Now, our organization does not actually resolve the disputes. It actually has a roster of expert lawyers in different fields, numbering in the several thousand, placed in different jurisdictions. And those experts are experts within their jurisdiction as well as the technology field. So the models are available out there in the international world to find alternative frameworks of resolving these disputes so businesses do not have to struggle with time, the cost of time, or the cost of fees. These are typically resolved in a very speedy manner. There are cases that are resolved in under a year or certainly under 2 years. So I urge you to look for other models to resolving these, these issues.
I have a slide here, the cost of litigation, and what's interesting is whatever reform has done, it most certainly hasn't rendered litigation less expensive or faster. And so these numbers and these statistics, I think, are sobering. Mark, and I'm going to flip back to where we're going to shift to the digital issues here in a second. But before we go there, there's so much of the reform is focused, as I noted earlier, on what happens after a patent issues, right? This IPR system, these post-issuance. Should we be doing more at the front end? And that is, make the process more cumbersome at the front end. Perhaps make it more expensive. Most certainly have it take longer. But from a patent owner's perspective, wouldn't you rather take a little longer at the front end, pay a little bit more at the front end, have a little bit more uncertainty at the front end as to whether or not this thing is going to issue, and then less uncertainty at the back end? Once you have it, it counts for something.
Luke, I think that's absolutely correct. I think the top priority of the Patent Office is to issue high-quality patents. And if that costs a little bit more money for companies, we can work through reduced rates for individual inventors or whatever it takes. But I think it's absolutely critical that the Patent Office issue the top-quality inventions and gets the budget it needs to improve its IT systems that allow it to do that. And it's having a huge impact. I started to see investment dollars because of that uncertainty that Judge Michel references, starting to shift outside the U.S. into other markets, China.
And how are you
Japan.
seeing it?
We're starting to see companies moving their research and their investment into those markets because those systems, those IP systems, are stronger and more reliable than the U.S. system because of these issues.
If you look at the venture capital statistics, until very recently, almost all U.S. venture capital stayed here. It was up around 85% stayed here. Now it's down to 50% that stays here. The rest is going overseas where systems are more supportive, where the return on investment is more assured, time to money, less risk. And in addition, there are a lot of investments that are shifting out of research and development into other things. And people who manage money have endless opportunities, alternatives, domestically and all over the world. So if you make the patent system unreliable, the money's going to go into something other than R&D, and that's already starting to happen at a very alarming rate.
We're going to shift, but before we do, Alan, last word. Because
Thank you. Well, so I go unrebutted, right? So I can say what look, I agree. I think we need to put more effort on the front end. That's part of the holistic solution. I think until we do that, I think it's not unreasonable to have more effort than on the back end until we've had a chance to do that. I think whenever you have change, there's uncertainty. I think if you've got a broken system, I think we have to invoke some degree of change and accept a certain degree of uncertainty. Last point is Judge Michel, you made the point about investment going overseas. I think there's a potential correlation, but I don't know that there's any causation. I think whether that's happening because the IP system is getting weaker, we're just talking about in the last year that this and I guess you'll show the slide that ranks the IP systems, and U.S. falling 10th. I don't think that the investment has shifted so radically, so quickly because of that. I think there's a whole bunch of reasons. I don't know that it's fair necessarily to attribute all of that shift to the IP system.
We're going to shift gears. We could spend all day and then some talking about this issue, but we're going to shift gear to digital right protection, and in particular piracy. And Suzie, being at Walt Disney, I mean, the company obviously has a huge stake in seeing rights in digital information protected and respected. Just from a macroeconomic perspective, if you will, can you give us a sense of what's at stake?
So in terms of shifting just to copyright in general, and one thing that actually I liked about this slide was that while my company is probably very well known, in particular for movies and television, the fact is copyright protects creation across many different articles, and many of those also the Walt Disney Company produces, whether it's books or games or software. And it does, as the slide indicates, it contributes significantly to the U.S. economy. And in a way that I think perhaps some people don't always think about in terms of the number of jobs and the quality of those jobs. And I can't see the whole slide, but I think it's on the slide that the fact is the average income of individuals working in the core copyright industries is higher than what the average income is kind of across the U.S. economy. And these are, like I said, many of these jobs, thousands upon thousands of these jobs are not the ones that you would necessarily, see either up on the screen or see in the credits of a movie. Thank you.
Now, I don't know if that's going to help you because the print's so small, but.
Though I will say now, if anyone's gone to, watch particularly any of the either superhero or action movies, and if you stay to the end, you will see the dozens upon dozens of digital artists that are employed to, create those special effects, which are then also patented, right? Going back to our first subject. But, so the risk here is if we aren't protecting the creation in our copyrighted industries, you do undercut, as was discussed in the patent area, you undercut the willingness of people to invest and to innovate and to put their products out there, because the only way you can kind of use the digital economy we have now and really make it work and distribute copyrighted content is you have to have, protection measures on that content. And strong enforcement laws to protect the content. One thing, that we reflect on often is the fact that when you were in the world of everything being, for example, either a book or even, a cassette or a record, as you would make, if someone wanted to copy those, as you would make your copies, every copy would kind of degrade a little bit more. So that, when you've got like the 20th copy down the line, you just knew it wasn't as good as if you'd gone in and, bought the fresh version. That doesn't apply in the digital world, right? Every copy is as good as the first copy. And also the ability to distribute those copies, worldwide in an instant is, creates just a large risk to the investment being made to create the content.
So I have a question of the audience and the students in the audience, and the answer is going to stay within these four walls. No one's going to tell on you. But who here has downloaded digital information without paying for it? Yeah, that's what I thought. And my daughter and my wife included. Okay. Who thinks that taking what doesn't belong to you is right? Okay. It's an interesting, I mean, I'm not surprised, Suzie. And in fact, if we look at the stats, most of the piracy, the plurality of the folks who pirate, fall within the 15 to 25 year age bracket. 26 to 35 is a close second. And Randy, you make part of a small group there, 46 to. But what is happening here? We have most folks acknowledging that they have, for lack of a better word, pirated digital information. And yet everyone here understands that taking something that doesn't belong to you is wrong. What's the dynamic here?
I think that there's several factors. One, I do think that people view it as quote unquote victimless, or and particularly we do hear this regarding movies at times, is, well, look at how much money that movie made. They're not going to, that company's not going to be harmed by my downloading a movie. And I think that what you really see over the years, because you look at, for example, the music industry and what's happened there, right? That it's really has shifted, mostly to online, but the music industry is not what it was 20 years ago. For a long time, they did not have technical protection measures around their digital copies, which made it very easy to both, burn a CD or, then copy the eventual copy over to your friends. And so I think from our side, we see it as, one, people thinking there's nothing wrong here because no one's being hurt. But all those individuals who are working in this industry, it does change the dynamics of the industry. And it changes it such that it's one thing if, again, a movie is making so much money that someone feels, oh, they were successful anyway. But there's a whole mid-core there of, movies that getting downloaded, 20 million times makes a difference, right? And some of those are movies that, some of us at times probably wish that there were more being made, because the number of movies being made is going down. And the reason is you've got to make them big. Some of this is, for the movies that have all the special effects, that the investment in terms of the technology. But second of all, what has happened over the years is the time frame from the date of a release of a movie to it showing up online is getting shorter. And it's getting shorter quickly. And what happens is, if you have a movie that's got lots of buzz, and maybe it is that mid-level movie, it is going to really impact you if it's online 5 days after it hits the theater and it's being viewed 20 million times. So there is another piece of it that I think people sometimes don't understand as well, that a lot of the sites where this content is available, about 1/3 of them are trying to download malware at the same time. They are not really safe places to be. And also, these are generally, particularly the popular sites, these aren't small businesses. Some of them are organized crime, but they are making a lot of money. They're making a lot of money, and they did nothing to create the content, and they are not paying anyone involved in the creation of the content.
What's interesting is, you were pointing out sort of these middle of the road movies from a budgeting perspective. It just, it sounds to me like piracy is making the margin for error much, much tighter, and shooing away, if you will, investment dollars. Mm-hmm. There's, Mark, from an IBM perspective, how does piracy impact you all
Well, we're one of the world's largest software companies, and we face piracy in a number of places. Not so much in the U.S. market, so we don't have a huge challenge there, but certainly in the international markets, piracy is a big issue for us. And we run into the same kind of issues that my colleagues at Disney and other companies have, that individuals, entities, bad actors are certainly trying to get a hold of our software and to copy it and make it available to others at a much cheaper cost.
Most of the piracy, and this is actually an interesting statistic, 74% of consumers said that they used a search engine the first time they found pirated content. Alan, I know you're no longer with Google, but I'll stick you with the company anyway. That's a sobering statistic, and I guess the question is, should internet content users, if you will, like Google, do more when it comes to piracy, and what are the practical issues at work?
So, you asked the audience the question about, who's downloaded songs or content, and a lot of hands went up, and you asked who thinks it's okay to steal, or, no hands went up. The truth is that, 20, 30, 40 years ago, it was the same thing, and like Suzie, you described, you mentioned records and cassettes. I didn't know if people knew what that was.
I know.
Right.
I hesitated.
It's just, but everyone made mixtapes, and we copied things, from records to cassettes, and played them in the car, and just gave them to our friends. So it used to happen. It just was a lot harder. Now what we see today, it's really technology is enabling distribution at a mass volume, and it's easy. You just upload, or you create a website, and now the search engine's going to find you and make it easy for everyone to find you through the search engine. And then you've got YouTube, the largest platform for user-generated content. Facebook has its share as well of content. So it's a hard problem. Part of what's happened is technology enables this. It makes it easy. Can companies do more? Sure. So we've got sort of the current law. We've got the DMCA.
The Digital Millennium Copyright Act.
And that has a process that it creates some obligation on companies to, when they're given notice, to remove infringing content. And there's a whole, way that this works. And I think then the question is, what more can you do? I think one of the things that is important, and I think at least in the U.S., we have to see how this plays out, but the DMCA creates safe harbor. So it basically says, look, if you're one of these internet service providers and you follow these rules, you're protected. You're not going to be liable for the illegal content on your site. One of the challenges is, on the question of what more can companies do, one of the tensions in terms of what companies can do is the DMCA also has some limits on the safe harbor, which is if you're too proactive, if you're looking for stuff, you may fall outside of the safe harbors and now expose yourself. And so we have to be careful in terms of the law to make sure that we don't create disincentives for companies to be proactive by taking away protections from them and encouraging them to try to do more of the right thing. And so we see YouTube has a tool called Content ID, where content creators can basically create a signature of their song, of their movie, and then the tool will be able to look for that showing up somewhere on YouTube. Facebook has its version called Rights Manager, similar type of thing. But it's a way for it's a tool for content creators to be more proactive, to be able to say, hey, I don't want to just, because I have to keep looking and searching manually, I want a tool that helps me find what's out there. And so we have these tools, and there's more that we're trying to do, but at the same time, trying to be mindful of the safe harbors and the laws that exist. And the other piece of it for Facebook is that we view our friends at Disney and other companies as partners. So it doesn't do us any good as a business if there's a lot of pirated content on our site.
But you make your money, a lot of your money, your income. I mean, I'll talk of Google. I know less about Facebook. Comes from advertising dollars.
Sure,
right?
sure, advertising.
And the more hits, the more your advertisers pay.
Yeah.
And so,
but-
is there an argument that you really don't have an incentive to be as aggressive about piracy as some might want you to be? Just I'm not saying
No,
it's
a fair question. I think on the flip, I think that is one position. I think the flip position would be we actually want to work with content creators and help them monetize, so that it's good for them and they'll want to be on our site. So we kind of look at this as, hey, are there ways that we can help create monetization opportunities for content creators? And we've tried some things. We're trying some things. We've got something called instant articles that basically will send people to another site for users to be able to pay for an article, let's say. And in that case, we give 100% of the revenue to the content creator. We don't take a cut of that. We have some challenges with some of our sort of intermediaries who want to take a piece of that, and we feel like that should go to content creators. So there are places where we're trying to find opportunities to partner and make it sort of a win-win for content creators and for us.
Suzie?
So first I will say, yes, we are working closely with Facebook, and we have a really, I think, very good partnership there. I do want to address YouTube, though, and Content ID. And it is, in theory, how it is supposed to work is that if you have content in terms of either a film or a television show, what you do is it's referenced as you fingerprint it, and the fingerprint gets uploaded into Content ID that YouTube has, and then that fingerprint is supposed to find either people trying to upload that something that matches that fingerprint, the same content, or content that's already on the YouTube system that's been uploaded perhaps before you created the fingerprint. Despite that fact, you can go onto YouTube and every single day find our content. And that doesn't mean that we're not using Content ID. What we have is a system that has a long way to go, and we do appreciate that Content ID exists, but it does not put us in a position of not having to worry about piracy and not having to actually expend significant sums checking platforms that do say that they have procedures in place. And then just to go back to the DMCA that Alan mentioned, the DMCA originally the idea was, right, there was a compromise here, and there was a safe harbor provided as long as a internet platform that wouldn't otherwise, that was somewhat kind of neutral.
Suzie, can I just interrupt?
Yeah.
When you were saying about the safe harbor, could you walk particularly the students through what that means? Who's the safe harbor for? What's it exist for?
Okay, so prior to the DMCA, there were lawsuits being brought against, and this is kind of going back in the internet years, because I think some of these were online billboards or bulletin boards, and they were being sued for what their users had posted on the online bulletin board. So, for example, someone copied somebody else's book and put it on, and there was an interest. I think, in Congress, in terms of the Digital Millennium Copyright Act, to say, well, you know what? We actually want to have more investment and development of online platforms and online intermediaries, whether they're, streaming services or online bulletin boards. And so we're going to create this compromise that as the platform, if you have no knowledge that something's been uploaded to your platform and someone tells you about it, as long as you take it down after you're told about it, you are not going to be liable to the copyright owner. And the copyright owner does need to give you notice. Unfortunately, what has happened over the years, from our perspective, is the way that the Digital Millennium Copyright Act has been interpreted has put more and more burden onto the copyright owner. And so, for example, one of the actual kind of intermediaries that falls in this area is search and search engines. And so there are each year probably millions of notices sent to Google to take down links to content that in the search engine, to content that is infringing. And they do. The problem is, if you're on the other side and you've got the pirate website, all you do is change the URL a little bit, right? You just put the content into a slightly different URL, and we have to go send another notice on the new URL. So how it is played out, which I think we kind of touched on a little bit in the patent area too, that it has turned out to not work quite, the compromise hasn't worked out quite how we was, I think, the original intent when the DMCA was passed.
Luke, there's another angle here that's worth mentioning, I think, and that is all of this is now global. What happens here also happens in other countries. When we have ineffective or weak enforcement here, whether it's patents or copyrights or other intellectual property, then our diplomats are negotiating with foreign countries to try to get them to strengthen their enforcement of IP rights for the same content, again, whether it's copyright or patent. And the foreign negotiators laugh at them. They say, we see what you're doing in the United States. You're weakening enforcement there, but you're telling us we should strengthen enforcement here. You're a hypocrite. We're going to watch what you do, not what you say. So we're undercutting our efforts all over the world by weakening things here at home unnecessarily.
Mark, sort of a question for you. If we have I have a slide up here just that summarizes what we call the online ecosystem. It's tangled, it's complex, and it's just growing more so, right? Particularly with technology being what it is and improving, if you will, as it is. Are our laws keeping up with the pace of technology? Because when we're talking about the digital DCMA, that's when was that enacted? It's 20 years old, something like that.
Yep.
20 years old.
I mean, that strikes me as just odd.
It's a problem across our IP, particularly in the copyright area, that our laws are 20, 30 years old and even older, and not only just for protection of IP, for subpoena laws and all those laws around getting access to IP. There's a case, the Microsoft case, going to the Supreme Court very soon, and that very issue about a law that's 30, 40 years old, and that's governing access to records outside the U.S. and whether you can get that through a subpoena or not. Congress has not been paying attention to this spot and to this space, and it's an area where there's a lot of good work that can be done. And certainly, I think the legislature should be focusing more on that issue. And also, I wanted to comment. We're talking about technology to try to solve some of these problems. I mean, in this kind of area, the crooks are going to always move faster than the businesses. I don't know that we're ever going to be able to keep up, to tell you the truth. And I think one of the things we need to ask ourselves, are we doing enough from a cultural standpoint to really focus on these issues and educate, just like we're talking about this IP education for undergraduates? Are we actually starting this education early enough in the school systems so students understand that it's not right to take this intellectual property, that you're actually impacting your neighbor in the LA area? You may very well be impacting your neighbor and putting your neighbor's parents out of work. Because of this stealing. I don't think we do enough in the schools to educate students about this and to really change the cultural perspective where so many people think it's no problem to steal these things.
Linda?
Mark, thank you so much for bringing that up. It's a very important aspect of intellectual property, is to continue building the general public's appreciation for its value. And there are many countries around the world that are really investing equally in enforcement as well as in education. And I think that's a challenge that the United States has to confront. I bring up the example of South Africa, for example, which is a hotbed of piracy. I mean, it's not the only one, and certainly there's a lot of piracy going on in the United States as well, so let me not single out our global partners. But South Africa has established a joint task force that combines the intellectual property unit of its government with its enforcement unit, and together they have both combined, donated a budget, or took budget out of their own individual budgets, and created a new unit that's focused on a combination of education and enforcement. What do they do for education, though? They, rather than punish and show the bad side of enforcement, they emphasized the good side, the value of creativity. They positioned creativity as a universal good. That's something anyone can aspire to and benefit from, whether you benefit from it in terms of personal growth or commercial gain. And they leveraged a very successful national pride campaign that was focused around nature conservancy, the big five big games, you know, lion, leopard, rhino, buffalo, and elephant, which have come under significant attack through poachers. That campaign, which was called the Big Five Nature Conservancy Campaign, was migrated into a Big Five Intellectual Property Conservancy Campaign with games, publishing, music, digital, I forget what the fifth one was, film. So the point is that governments can do a lot to educate young people that they can be the owners of tremendous creative value, and they themselves can begin to appreciate the value of creativity, and therefore will hopefully transfer and pay it forward, you know, appreciate the value that other people bring to them through professionally developed content.
I wanted to, hold on a second here, wrap up with one last slide, and we'll wrap up here, and then we'll take some questions. Judge Michel, this is, I think, the study that you've cited in some of your writings and speeches on the subject of the state of U.S. IP. U.S. does not stand number one, at least according to this survey here. I don't want to get so much into the debate about whether it's as bad as this suggests it is, because I know that Alan has different perspectives. We all have different perspectives on it. But what I want to focus on is just the implications of a robust U.S. IP system from a global perspective. How important is it to have an IP system that works, and Linda, to your point, that's respected?
Well, I think it's the single most important thing that America can do, because our competitive advantage on the global scale is our ability to innovate. And that depends on protection and investment and all these other things we've been discussing. The figures that were mentioned, 80% of the value of publicly traded companies is in intellectual property, 40% of the GDP, and so on and so on. It's our present. It's our short-term future. It's our long-term future. We got to get this right, or we're going to go into terminal decline as a country economically. So it's not just a question of pride, you know, are we number one or number two? It's a question of, do we have the foundation of a viable economic future? Can we create the jobs we need for millions and millions of Americans? And we have, you know, technology helps in a way, but it hurts in a way because it destroys a lot of jobs with disruptive new technologies. So then we need other creative efforts to create new jobs as fast as we're losing the old jobs because of these changes. And if we don't have an extremely vibrant IP system across the board in this country, we're not going to be able to create the jobs. We're not going to be able to compete globally. It's the single most important thing we need to do. It doesn't get the attention it deserves in universities, in the Congress, in the media, and everything takes place in a context. So Linda talks very correctly about the value of mediation or arbitration or other non-court resolution of disputes, particularly in the intellectual property area. But if the enforcement systems that are the backdrop are so weak, why should I mediate? If I'm accused of infringing a patent or infringing a copyright and the enforcement is weak, there's no incentive for me to mediate. You know, in the 90s, we had what I called the honor system in the patent world. IBM, for example, licensed billions of dollars worth of technology to hundreds and probably thousands of companies, and they never had to file a lawsuit because the people who were using the technology observed the honor system and they took licenses. Now we have the opposite of the honor system. Now we have people who see that because of the weakness of enforcement and the fragility of issued patents, it makes more sense to just go ahead and infringe. So that's not a good place for us to be. We don't have to be there. It's our own choice. No power from outer space is forcing us to weaken enforcement and change our culture to encourage people to infringe so we can get back to a place. We know how to do this. We did it for 200 years successfully. Almost every big invention in the world in the 20th century was done in America. That's not true anymore. We know how to do it. We did it before. We ought to get back to it.
Alan?
Well, I mean, one thing we have to make sure we understand, too, is that it's not the filers of U.S. patents are not just U.S. companies. I mean, we're talking about foreign companies. There are more foreign companies who file patents in the U.S. than U.S. companies are. So while I completely agree with you about the importance of making sure that we have an economy that's strong and we create the right incentives for people to invest here, I don't think it's fair to, what I don't want us to do is overemphasize the importance of patents at the expense of everything else that's also important as well. There's other forms of intellectual property that are really important. Trade secrets, copyrights, trademarks, we haven't even talked about. Those are all important pieces of the toolbox, if you will, in terms of how you protect and how you go to market. But I don't know. I think there's a lot of other aspects as well, investment and other things, access to capital. So I think it's all about a balance, and how do we strike the right balance? I think we are very committed to a single patent system for all industries. Does it make sense to reconsider that? Does that make sense? Okay. I don't know. I mean, there are some serious overhauls you could make if you started from scratch. Are we ready to do that? What we've done till now is piecemeal reform, largely through Supreme Court decisions. If we really want to make big change to make sure that everything fits together, you'd almost have to sort of, I wouldn't say scrap it, but really look at everything. And a lot of what I think, the eBay case we didn't call it the eBay case, but the case you referenced on injunctions, that was a fundamental change in terms of how we understood patent law to work. We used to always say that it was a right to exclude. I don't know that it's fair anymore in the U.S. to say having a patent is a right to exclude if you can't get an injunction.
Right.
So we've changed, and part of it is that technology changes so fast that the systems never can keep up. Mark said that the good guys can't keep up with the bad guys, or when the good guys do something, the bad guys are always ahead of them. Well, the truth is that everyone is ahead of the legal systems. The legal systems are slow. And so if we're going to address sort of copyright, digital protection, I think what we need to do is I think the awareness is absolutely right. I think we need to align business interests so that the content creators have the same alignment in terms with the platform providers and the internet service providers, so that we're all sort of in it together. If we have different interests, we're going to do different things. And the legal system, I think, will always be behind.
Well, I agree with Alan that balance is the single most important thing. It has to work pretty well for almost everybody in every technology, every size company, every business situation, every part of the life cycle of a company. But to do that in so dynamic a circumstance as we have in terms of business, in terms of technology, we need to get the Congress to do a much better job, because the balance isn't static. What's a good balance one year might not be a good balance 5 or 10 years later. So the Digital Act is 20 years old, ridiculous. The American Invents Act is already 6 years old, and the rebalancing needed hasn't occurred in either case. It can be done if we just get the Congress to do its job.
Can I touch on that? So The 1976 Copyright Act was intentionally technology neutral. And in part, that was a result of all the changes that had been happening from the 60s into the 70s around television distribution. And so because of the reasons that have been said here, which I totally agree with, that as soon as you can manage to deal with one type of technology that supports piracy, there's going to be another one. And I don't think we would ever be in a situation where Congress could be passing laws like that to be on top of things. It just isn't practical. But having laws that kind of are technology neutral but are very clear on the fundamentals and what's being protected, and which again is what the 1976 Act tried to do in terms of your core, your bundle of copyright rights that you get as a copyright owner in terms of distribution, public performance, et cetera. And then have them, appropriately applied. Because I think part of the problem with the DMCA is it actually did try to be very technologically specific. And as Judge Michel mentioned, the problem is the bargain that looked like the right balance and compromise 20 years ago may not now work for everybody in the mix. But I do think, and it was on a prior slide, that the question of and I do think our economy has benefited so much from the growth of the internet. But at a certain point, when you look at all those people in the ecosystem on the internet, doesn't everyone bear a little bit of accountability for it working correctly and lawfully?
What I'd like to do is, on the note of hoping that Congress is going to do something, what I want to do is turn it over to the audience for some questions of our panel. Does anybody have questions? Yes.
Hello. So there have been issues surrounding the price and strenuous defense of patents in the medical world. An example that comes to mind is AZT during the early years of the AIDS epidemic. The company defended itself by stating that the high price of the drug was justified because a lot of money was needed in AIDS research. And public opinion is already pretty unhappy when there are anti-piracy laws. As has been stated, it's viewed as a victimless crime, and it's outraged when people's health and lives are concerned. So where is the right balance between research, profit, and availability for these drugs to people who are in need? And also, how do companies react to public opinion? For example, HBO, when 4 episodes of Game of Thrones leaked before the season started 3 years ago, said that they didn't care how you watched the episodes as long as you enjoyed them.
All right, lots of questions. Anybody want to take on one or two of them?
I'm pretty sure Judge Michel said he wanted to.
Well, it's hard to grapple with all of the suggestions that the gentleman made. Look, I think that our society is perfectly capable of not only creating great technology, but also managing legal systems that are part of the picture. There's no reason why Congress can't be well informed by experts like some of the men and women in this room or on this stage. They don't have to design everything themselves from scratch. They draw on expertise in hundreds of areas every year. The same thing with government agencies, whether it's the Patent Office or the Copyright Office or any other agency. They can draw on expertise from the private sector. There are many challenges. Drug prices are a good example, but there are many solutions, and some of them can be worked out privately. Some of them require legislation. Some of them require international combined efforts. But these things are all doable. This is a question of will. I talked earlier about investment. It's not just the investment of money. It's the investment of time and talent and desire to achieve certain goals. If we muster the will, we'll solve the problems.
I would just say this, is that I think you're asking the right questions. Those are really hard questions that you asked, all 10 of them. but they're the right questions, and a lot of them don't have an answer. I think there may be some answers which we know would be like where you've gone too far. If you regulate drug companies where they have to sell drugs for a certain price and they can't afford to now invest in the research necessary to discover the next drug for them to recover, and they just say, we're out of business, we can't do this anymore, then you know you've gone too far for sure. But there's a lot of gray in between, I think.
And I think we know one answer is that these decisions shouldn't be made by courts. These decisions need to be made by legislatures who can study the issues and understand them in great detail and really make policy decisions rather than trying to deal with these in a peaceful
You know, having been a judge for 22 years, it always sort of amazes me how readily much of our citizenry assumes, there's no real proof of this, there's evidence to the contrary, but the citizenry assumes that lawyers who now wear black robes have some sort of magic to answer all the problems of the society. And they don't. We don't. We can do certain things. We can adjudicate cases. We can apply procedures. We can assess standards and so forth. But we aren't the source of the ultimate accommodation of conflicting forces in the society. That necessarily is the work of the legislature. And there's no way around that. It can't be done by White Houses or governor's offices, and it can't be done by courts either. These big issues, the 10 questions that Alan and the gentleman in the audience are fencing on, those are inherently, necessarily legislative issues. And we just have got to get the Congress to be better informed, more focused, and help us accommodate some of these complex problems.
So we're about out of time. Here's what I propose. We are going to have a reception outside here that's going to go about a half hour, 25 minutes, a half hour, and then it's going to be followed by a private reception. But certainly the initial reception here, students and everyone else is invited. Please approach our panelists and ask them, whatever questions you may have, and they'll try to answer them, I'm sure. And again, I think we're gathering out this way. And then in about 25 minutes, we'll have a private reception that starts in the back. Before we adjourn, I think we had some gifts for our panelists. And we're supposed to have our chaperones lined up to give them the gifts. Our chaperones, by the way, are part of our course here. And while they pick this up, a round of applause for our panelists.